This presentation is going to cover forfeiture, non-use, and rebuttable presumption of quantity impairment due to non-use. Let's start with forfeiture. Forfeiture is a fundamental concept of the prior appropriation doctrine in the state of Utah. The definition of forfeiture comes from Section 73-1-4 of Utah Code, which is sometimes interpreted as use it or lose it. A water right is subject to forfeiture if it hasn't been used for a period of 7 consecutive years. This means you can use it for 1 year, then not for 6, and then use it again, and that water right wouldn't be subject to forfeiture, but you'd have to have evidence showing that it had been used at least once in that 7-year period. There is an exception to the 7-year rule. If a water right is not used for 7 or more consecutive years, but no recommendation for forfeiture has been made, and it is then put back to use for 15 consecutive years, the water right is no longer subject to forfeiture. In other words, a forfeiture action cannot be filed against a water right that has been in use for the most recent 15-year period. A forfeiture action is a judicial action. The state engineer does not declare a water right forfeited. The state engineer performs administrative actions. In other words, the state engineer does not take away a person's water right. They can make a recommendation to a judge that a water right be disallowed, but it is the judge that makes a decree that a water right is forfeited. What happens to a forfeited water right? Once forfeited, it reverts back to the public. In other words, the water associated with that water right now becomes public domain. If the forfeited water right is in an area that is closed to new appropriations, then the water just gets used in priority, meaning the junior water right holders may get more of their water rights fulfilled each year because that water right has been forfeited. If it's forfeited in an area that is open to new appropriations, then that water is now available to be appropriated, and a potential user can file an application to appropriate in accordance with the appropriation policy for the area. If you are wondering if a water right has been forfeited, you can look it up in our database. The status line should say terminated or disallowed, but it is always recommended that you review the scanned documents to determine the status of the water right. As mentioned, forfeiture is a judicial action. Who then files a lawsuit to create this forfeiture action? Primarily, it's an aggrieved party. For example, say there's a spring, and the spring serves 2 water users. The first water right holder decides not to use their water right for 7 years, but in the 8th year they come back and they start using it again to the detriment of the other water right holder using that spring. The second water right holder would be the aggrieved party, and they could file a forfeiture action against the first water right holder. But if they don't do that for 15 years after the first right holder put his water back to use, then that water right is no longer subject to forfeiture. A forfeiture action is generally performed through an adjudication. This means the state engineer would make a recommendation to the court, but ultimately it's the judge that disallows a water right and then decrees it is forfeited. Next, we'll cover exceptions to non-use. The first is an approved non-use application, which we will discuss in more detail later. Next is a written terminable lease or other agreement with the appropriator or the appropriator's successor in interest. An approved state agreement or federal conservation fallowing program can provide an exemption to non-use. Another exemption to non-use is if there is insufficient water in your source to satisfy the right. For example, let's say you have a junior water right on a stream, and the stream cuts out every year except for 1 out of 10. For those years where water is unavailable, the water right is excused from non-use. Priority cuts can create an exception to non-use. For example, if you're on a system like the Weber River, the water rights are regularly curtailed up into 1865 priority. If the water right isn't used to its full extent, and it's because of priority regulation that can be demonstrated to the division, then that portion of the water is not subject to forfeiture. Another example is if a water right is curtailed due to the requirements of a groundwater management plan. If your water right is in a water storage, surface, or groundwater recharge project, that's also excused. If you are using substantially all of the water right that you're allowed to use, that's excused. Water rights held by a public water supplier for future needs of the public are also excused, but an important note is that for those rights acquired after May 5, 2008, they are subject to the same rules as general water right users, with some exceptions. Pursuing a change application will protect the water from non-use, and the public water supplier can then hold the water rights for the future needs of the public. If the water rights are supplemental, then the water rights are also excused from non-use, as long as the other available rights are being utilized in a manner that doesn't require beneficial use of the supplemental right. A water right is not subject to forfeiture during the time a change application is approved and diligently pursued. This list is not entirely comprehensive, but remember that if you are trying to use your water right, you're probably excused from non-use, and there may be some way that the division can work with you to avoid the consequences of forfeiture. Now let's discuss how you apply for non-use protection. A non-use application is the easiest protection you can carry as a water right holder. Non-use applications allow a water right holder that knowingly does not want to use their water right to be protected from forfeiture. Non-use applications protect the water right from the date of filing to the date of approval. Once the non-use application expires, that water right is no longer protected. The non-use application does not protect a water right that is already subject to forfeiture. It is important to note a non-use application does not constitute beneficial use. For example, if you have a water right that you haven't used for a 7-year period and you file a non-use application and you do that for 15 years, that's not the magic 15-year period. That water right is still subject to forfeiture. You can file a non-use application on all or part of a water right. A non-use application may be filed by the appropriator or the appropriator's successor in interest. A shareholder can file a non-use application on their portion of stock that they own in a company, but they need to provide written notice to that company that they are planning on filing a non-use application. A non-use application does not prohibit you from using your water right in part or in full. Even with a non-use application, you are still permitted to use your right to the best of your ability. Most non-use applications are approved. Utah code says that the state engineer shall grant a non-use application, and so the state engineer more than likely will approve a non-use application that is filed with the division as long as the cause for non-use is reasonable. Reasonable causes can include financial hardship or economic depression, physical causes that render use beyond reasonable control, so long as the water right owner acts with reasonable diligence to resume the use. Participation in a water conservation or efficiency practice, or groundwater recharge recovery program, or the water right being part of a legal proceeding where a judge has restricted the use of the right. Additionally, if water is held by a public water supplier to meet the future requirements of the public, that's a cause for non-use. Also, if there's a management plan in place and non-use of a water right will help with that management plan, then that's a reasonable cause. If the source that you're using has a loss of capacity due to deterioration of the supply equipment, that's also a cause for non-use. In that case, the state engineer expects a plan regarding how the water supply equipment will be restored. There are other reasonable causes, and you can reach out to the Division of Water Rights if you have questions about a cause for non-use. 60 days before the expiration date of a non-use application, the state engineer will notify the applicant, and the applicant can file additional non-use applications or simply allow the non-use application to expire. Let's move on to quantity impairment as the state engineer looks at quantity impairment for the approval of a change application. Quantity impairment is a reduction in the amount of water available to an existing water right if a change application is approved. This includes changes in the timing of water or enlarging the depletion of the existing water right. A change application will likely not be approved if it quantitatively impairs an existing water right. Quantity impairment has a statutory basis in a change application process as defined in Utah Code 73-3-3 and 73-3-8. It is important to note that 73-3 subsection 1e Roman numeral 2 clarifies that quantity impairment does not mean a decrease in the static level of water in an underground basin or aquifer that would result from an action proposed to be taken in a change application, if the volume of water necessary to satisfy an existing right otherwise remains reasonably available. The applicant in the change application process bears the burden to provide evidence first that the change can be made without impairing existing water rights, and second, that rebuts the presumption of quantity impairment. The first protects senior water right holders from junior water right holders moving to their source of supply and impairing their right. The second protects junior water right holders from senior holders putting a right back into use, which can be a bit confusing, so let's look closer at how that works. Rebuttable presumption of quantity impairment is a mechanism used by the state engineer to consider non-use of a water right during the change application process. Basically, if it appears that all or a portion of a right has not been diverted from the approved point of diversion or put to use at the approved place for a 7-year period, the state engineer may presume quantity impairment to the junior water right holders if the senior water right holder puts the right back into use under the authority of an approved change application. Utah statute gives the state engineer 90 days to raise the rebuttable presumption of quantity impairment from the date of filing of the application. Protestants to an application can also raise a rebuttable presumption of quantity impairment, as long as they do it in a timely manner during the protest period. To do this, they must identify a water right that is junior to the base water right of the change application that will experience quantity impairment if the senior water right was put back to use. If a rebuttable presumption of quantity impairment is raised, the change applicant can rebut it by filing documentation showing the water was used according to the right during a period of 7 years, or by filing documentation that excuses the water right from use. This can include an approved non-use application or one of the reasons outlined in Utah Code Section 73-3-8. If the applicant cannot rebut the presumption of quantity impairment or demonstrate how the presumption does not apply, then the application will be rejected. Rebuttable presumption of quantity impairment also does not apply if your non-use falls under 73-1-4 subsection 2E, exceptions under in-stream flow, or if the 7 years of consecutive non-use occurred more than 15 years ago. What are the non-use exemptions under 73-1-4 subsection 2E? These are the same ones we talked about earlier, namely a terminable lease, fallowing, insufficient water, priority cuts, water storage, substantial use of the right, water suppliers with a right acquired to May 5, 2008, a supplemental water right, or a right that's part of a change application that is being diligently pursued. Finally, one note on leases. If you have a lease, you will need a written document with terms of the lease, including an understanding that, if a change application is approved, the lessee will cease using the right. Let's test our understanding with a few scenarios. Scenario 1. A farmer files a change application on a water right with an 1890 priority date. The historical place of use is now a Walmart parking lot and has been for 10 years. A protest has been submitted alleging quantity impairment due to non-use. Protestant's water right has a 1910 priority. Has a rebuttable presumption of quantity impairment been raised? Could basic quantity impairment be an issue? The answers are yes. The rebuttable presumption of quantity impairment has been properly raised. By beginning to use a water right that has a senior priority date but is subject to forfeiture, the applicant creates a situation where a junior water right that may not have been impaired becomes potentially impaired if curtailment in the basin were necessary. This is particularly true in areas that have been declared critical management areas where the amount of water depleted each year exceeds annual recharge to the basin. Basic quantity impairment could also be an issue. An example could be moving a senior right into a surface system where a junior right has been operating, and with the movement sees a decrease in available water. Scenario 1A. Farmer Bob files a change application on a water right with a 1940 priority date. The historical place of use is now a Walmart parking lot and has been for 10 years. A protest has been submitted alleging quantity impairment due to non-use. Protestant's water right has a 1910 priority. Has a rebuttable presumption of quantity impairment been raised? Could basic quantity impairment be an issue? A rebuttable presumption of quantity impairment has not been raised, as the senior 1910 right in this scenario could continue to be used. In a similar example used previously of a critical management area, the 1940 water right would be curtailed prior to the 1910 water right. Basic quantity impairment could still be an issue. An example could be moving a junior right into a surface system where a senior right has been operating. Without proper administration of rights, the senior right could be impaired. Scenario 2. A change application is filed on a water right in 2022. An approved non-use application was filed in 2016. It is clear and obvious the water right has not been used for more than 7 years prior to 2016. Can someone raise rebuttable presumption of quantity impairment? The answer is yes. The non-use application does not constitute beneficial use. The 7-year period is 7 years prior to the filing of the non-use application. The applicant should submit evidence of use either with the non-use application or the change application in order to rebut the presumption of quantity impairment. Finally, some recommendations on how to proceed if you are the applicant and a rebuttable presumption of quantity impairment has been asserted. First, don't ignore the presumption. It is the applicant's burden to bear. Second, verify whether the non-use is excused using those reasons in Utah Code Section 73-1-4. Third, it may be worthwhile to present the information with the change application before a rebuttable presumption is made. Fourth, if the water right was used in an unapproved location or from an unapproved point of diversion, provide a trustworthy, terminable lease agreement documenting the periods used. Fifth, if there was indeed verifiable use occurring under a terminable lease agreement, provide a heretofore map that shows what will be retired. Sixth, understand that not all scenarios are equal and may require some judgment. However, the state engineer is required to operate within the confines of statute when considering applications with this burden. For further understanding of the issues presented today, the state engineer recommends a thorough review of statute, and of course, Division of Water Rights offices are open to public inquiry.